All rise. Oyez, oyez, oyez. The Supreme Court of the United States is now in session. Chief Justice Corman and Justices Brody and Clifton are presiding. All those having business before this honorable court are admonished to draw near. God save the United States and this honorable court. The first case before the court today is United States of America versus John Habib.
Please be seated. Whenever you're ready.
Good evening, Your Honors, Mr. Chief Justice, and may it please the court. My name is Soha J. Farzad, and I, along with my co-counsel Amy Yellen, represent the petitioner in this matter, Mr. John Habib. While my co-counsel will address the latter issues regarding juror misconduct, I will address two independent reasons that require reversal of the 14th Circuit. Namely, first, that Federal Rule of Evidence 702 does not categorically exclude credibility testimony from an expert, and second, that the collective entity doctrine does not extend to the former corporate employee of a corporation. At this time, I'd like to reserve 2 minutes of my co-counsel's time for rebuttal. Thank you, Your Honors. Turning to the first issue before this court, Federal Rule of Evidence 702 does not categorically exclude credibility testimony. As a preliminary matter, it's important to note that this court is only deciding whether, as a matter of law, this type of testimony is excluded. And so if this court can imagine a single scenario where this testimony should be admissible, the 14th Circuit should be reversed. And the federal rules are clear that there are no such categorical exclusions from testimony that is admissible.
But the judge admitted some testimony in this respect. He didn't exclude all of it.
Yes, Your Honor, but the threshold inquiry for whether or not testimony is included or is excluded is not whether some testimony is admitted. But as this court noted in Daubert versus Morel-Dow Pharmaceutical Companies, Federal Rule of Evidence 702 has a two-pronged inquiry. First, whether the testimony is expert under Rule 702, and second, whether or not it's helpful. This category is broad, and there are no categorical exemptions.
I know, but can't you break up into two parts the expert's testimony? The first part, which was admitted, described the disorder that the witness suffered from as being characterized by a pervasive pattern of disregard for and violation of the rights of others, as indicated by a combination of the following: deceitfulness, as indicated by repeated lying or conning of others for personal profit or pleasure. And I'm going to stop there for the moment, although he concludes by saying that remorse as indicated by indifferent at telling frequent lies. And as I understand it, that part was admitted, and what the judge excluded was the conclusion of that this particular witness is not likely to testify truthfully. So why was that an abuse of discretion?
Well, Your Honor, this court is not looking at whether or not it was an abuse of discretion, but only at the matter of law exclusion of that testimony. So this is being reviewed de novo, and that's where the 14th Circuit and the district court erred. They relied on a common law notion that determinations of credibility are the sole province of the jury. But this court made clear in Daubert that when the federal rules demand an analysis and they clash with common law notions, that the federal rules analysis must prevail. And that's what petitioner asks for today. Not that this testimony be admitted as a matter of law, not that any specific expert should be allowed to say whatever he wants. Simply the analysis that Rule 702 demands must be conducted by a district court judge, not a categorical exclusion. This court stated in Kumho Tire Company versus Carmichael that no category of testimony or expert can be ruled in or ruled out as a matter of law. And there's only one rule that excludes testimony, and that's Federal Rule of Evidence 704. 704 prevents ultimate issue testimony when it speaks to the mental state of a criminal defendant when that mental state is either an element of a crime or an element of defense. That is the only categorical exclusion from admissible expert testimony. And so this case is a clear application of inclusio unius est exclusio alterius.
Well, what are you suggesting if we agreed with you?
Your
In
Honor,
other words, it would go, the judge, on a retrial, presumably, the judge could still exclude it? Any exercise of his discretion?
yes, Your Honor, this court has made it very clear. District court judges have a wide discretion in what expert testimony to admit and to exclude. And to that extent, if the district court here had found under Rule 403 that this was too prejudicial, or under Rule 702 that that was helpful or not helpful, that wouldn't have been the proper analysis. But this court has made it clear that harmless error analyses are not to be conducted. Rather, the only question before this court is, as a matter of law, in every circumstance, is this type of testimony excluded? And it's clear that they're not. Especially in this case, we can see why this type of testimony is helpful for the jury in making their determinations. And this court defined helpfulness as simply relevance in Daubert. So the question is this type of testimony relevant for the trial? Does it bear on the facts or material issues in the case? And it's clear that as a matter of law, for the threshold inquiry, they do.
What precise evidence did you hope to have admitted that was excluded by the judge? I mean, the expert was allowed to testify as to the condition that he diagnosed and to the effects of that, so what's left out?
Your Honor, he was allowed to testify to the symptoms of Reed's disorder generally. But as Mr. Chief Justice has pointed out, there's a broad range of symptoms that can attach to Reed's disorder. So what Dr. White wishes to testify to is what conditions of Reed's disorder are manifesting in Mr. Roberts. Not every single possible symptom, but those that are actually manifesting. And he must be able to do that. Imagine another disease, for example, depression. Depression has a range of symptoms that can range from merely not affecting the individual at all to near incapacitation. The respondent's position is that an expert should testify to the whole range of possible symptoms that can attach to a disorder and then have the jury draw the inference. This court can imagine the inverse of the case before it. Imagine if Mr. Roberts did not have the symptoms of Reed's disorder that affect his credibility, but rather, as page 21 of the record shows, merely those that touch on impulsivity or aggressiveness. The respondent's position is that still, Dr. White would testify that Reed's disorder manifests in a pattern of disregard of the violations of the rights of others as indicated by repeated conning or lying. And that's the difference here. All Dr. White wishes to do is to testify as to what symptoms manifest in Mr. Roberts.
Well, why couldn't he? At least to the extent that he knows based on his past experience with the defendant.
Because the district court affirmed by the 14th Circuit found that as a matter of law, if an expert testifies to the credibility of another witness—
Well, that's a different question. That's asking, will this witness, when he testifies at this trial, testify credibly? That's not the same thing as asking him, in your experience, has this individual, not a witness in that context, testified or commented or spoken truthfully in the experience that you've had? Was there anything that precluded the witness from expressing his experience with this particular individual in his previous interviews of the individual?
To the extent that Dr. White was not allowed to testify that the conditions of the jury room would trigger Mr. Roberts' effects of Reed's disorder.
You mean the courtroom?
In the courtroom, sorry, Your Honor, but on the stand.
So that's a projection to the future. And it's not something that the witness, in this case, forgotten his name.
Right.
Dr. White can testify to based on his experience with the individual. He's testifying based upon what I think he will do in this particular context. That's a projection with somewhat less reliability than the other kind of testimony he's trying to offer, isn't it?
There's a critical distinction between what Your Honor is proposing and what Dr. White tried to say. All Dr. White tried to testify to is that it was likely, given the pressures of the courtroom, not that Mr. Roberts would lie, not that he will lie, but that the symptoms of his disorder made the likelihood increase, that it was likely that he would lie, given the pressures of the courtroom.
He basically said that he's essentially a liar to begin with, and that testimony was admitted. I'm not quite sure I understand your all or nothing argument. As I read the Court of Appeals opinion, it said he didn't categorically exclude the expert testimony. The district court spoke about what the district court admitted, which he's prone to lying.
Yes.
And said that the rest of it would not necessarily have been helpful.
I'm sorry, Your Honor, to clarify, it's not that Dr. White's testimony was all categorically excluded.
Right.
But it was that the final determination of credibility was excluded as a matter of law.
Why isn't the jury capable, once they have his general assessment of the condition, capable of drawing their own conclusions about whether he's testifying truthfully or not? It's pretty devastating what was allowed. I'm not arguing about harmless error. I'm simply talking about helpfulness and the conclusion essentially that its probative value is outweighed by its potentially prejudicial effect.
Because you're...
I don't want to answer this question and go on to your next point.
Absolutely, Your Honor. Because that would be a 403 analysis, not an analysis under Rule 702's threshold inquiry. 702 asks two questions. Is it expert knowledge? Neither party contests that. And is it helpful? And that's all it asks. Turning now to the second issue before this court, and an independent reason that warrants reversal of the 14th Circuit. The collective entity doctrine does not extend to the former agent of a corporation. This court held in Braswell that the long history of the collective entity doctrine has changed in the wake of United States versus Fisher and United States versus Doe. In those two cases, this court created the act of production doctrine. And the act of production doctrine states that when an individual responds to a subpoena, they testify. They testify that the contents of those documents are the same as the ones requested by the government, that they have the documents, and here it provides a missing link that the government needs. It provides the link between the contents of the documents and that Mr. Habib had knowledge that Genius watches are unsafe. And that's why the government needs...
Where's the link? What's the link there?
The link is that if the jury knows that Mr. Habib was in possession of the documents, they can draw the inference that he not only had the documents...
Well, I thought the limitation was imposed that this simply would obtain the documents, but the government would not be able to use the fact they'd obtained them from him. Isn't that the case?
That's incorrect, Your Honor. In this case, Mr. Habib has not been granted use immunity. If he had, then there would be no
Well,
case.
use immunity is something else again. That means they couldn't use them against him. They could use them, but it's my understanding from the record that they did not use the fact that they obtained them from him.
Sorry, Your Honor, let me clarify. Not use immunity with regards to the contents of the documents, but the act of producing them.
Yeah,
Petitioner,
but that's what he essentially got. They weren't going to tell the jury where they got the documents from.
no, Your Honor, that's not quite correct, and that's not in the record. If that were the case, then petitioner would have no argument before this court.
Was the jury told, counsel? My understanding from reading the record is that the jury didn't know who produced the documents, simply had the documents before them.
Isn't that the limitation that Braswell explicitly provides?
No, Your Honor. Braswell provides that protection in the face of a non-agent. But when an agent produces under the umbrella of a corporation, then there is no reason to extend the Fifth Amendment, as this court held in Braswell. And so if Your Honors believe that the act of producing these documents is actually immunized, then petitioner has no argument for this second point, but it has not been immunized. This court held in Braswell that
It hasn't been immunized in the sense that there was a formal grant of immunity, but essentially the evidence that he was the producer was not before the jury.
Your Honor, to the extent that this court is observing this issue of law, if respondent's position prevails, then the production of those documents can be used because it's not a personal production, it's a production of the corporation.
And what about the Supreme Court's decision, I think, in Bellis? That would involve the partnership that had been dissolved, and they got the records from a partner.
Yes, Your Honor. Petitioner concedes that this court has on 3 occasions ruled the opposite of this position, but that was all before the act of production doctrine and all before this court's decision in Braswell. And in Braswell, this court noted that the act of production doctrine has necessarily changed the question. The question is no longer what are the contents or nature of these documents. The only question is, does the individual produce those documents as an agent of the corporation, or do they do so as an individual? And here it's clear. Mr. Habib has not worked for Zodiac for the last 2 years, And he has no authority to act under Zodiac's name. And so he cannot be said to have an authority to turn these documents over as a representative of Zodiac when he has no authority to do so.
And how did he get the documents?
Your Honor, at the time he obtained the
From
documents.
Zodiac.
From
And
Zodiac.
he wouldn't have them if he didn't have a relationship with Zodiac.
No, Your Honor, he was
And the only reason they're asking him is that Zodiac doesn't have them anymore.
correct, Your Honor. But to the extent that the government can't obtain the evidence without violating the Constitution, this court has never held that that's a sufficient answer. And so in this case, when these documents are held by Mr. Habib, are subpoenaed in his name to use against him in his own criminal trial, this court should hold that the Fifth Amendment does not compel that production.
Do you have one more point that you wanted to argue?
No, Your Honor.
You've covered your 2 points.
Yes, Your Honor.
Okay.
Thank you very much.
Good evening, Your Honors. Mr. Chief Justice, and may it please the Court. My name is Amy Yellen, co-counsel for petitioner Mr. John Habib. I will be addressing why the bias statements made in the jury room are admissible under the first exception to Federal Rule of Evidence 606B, as well as why these statements violated Mr. Habib's Sixth Amendment right. When it comes to light that jurors have reached a verdict based on bias, not evidence, the federal rules and the Sixth Amendment demand inquiry into the validity of the verdict. Accordingly, for the following 2 reasons, this court should reverse the decision of the 14th Circuit. First, federal juror testimony regarding bias is admissible under the extraneous prejudicial information exception to Rule 606B.
What was extraneous about the information?
The extraneous portion of the information is regarding Mr. Habib's supposed terrorist affiliation, as well as Mr. Habib using the Genius watches as some sort of terrorist plot.
None of the other jurors did their own internet research or went to the site or anything else. They wound up displaying to their fellow jurors attitudes that they had before they stepped into the jury room.
Your Honor,
People are constantly reflecting on their own past experience in the jury room, and we permit that. Sometimes we may not like it, but we permit it. How is this any different? What makes this extraneous?
Your Honor is correct that generalized bias would not be admissible under this exception. So if here the statements were simply all Muslims are terrorists, that would be inadmissible. But as this court defined in Werger versus Showers, extraneous is a distinction between external and internal matters. External referring to publicity and information outside the trial record that specifically relates to the defendant or the facts of the case. Here we have exactly that. As reflected on pages 26 and 27 of the record, in an affidavit submitted by juror number 3, statements were made such as, how can we possibly believe this towelhead? He's clearly out there killing Americans with these watches as some sort of terrorist plot.
Well, how is that more, you mentioned Warger, how is that more extraneous than the reference by the mother that my daughter had been involved in this kind of accident, and if she'd been sued, it would have ruined her life and so forth? That happened outside the jury room. It's an experience brought inside, and yet the court unanimously held that wasn't qualified for the exception. How is this different?
Your Honor is correct that fell more into the internal matters, meaning the common body of experience that jurors are expected to bring into the jury room. There, a juror was relaying her own personal experience, and that falls under internal matters. But external matters are what we have here. Here we have jurors introducing outside information that was never
How is
introduced.
this any more outside? In that case, it was the experience of one juror's daughter who herself was involved in an accident. That surely happened outside the jury room and outside the courtroom, and yet the court concluded that was not extraneous. This is a prejudice. This prejudice may be based on things that happened outside. Certainly the reference to towelhead and terrorism has something to do with other than this courtroom. And yet, it doesn't seem to me to be any more outside than what the court dealt with, what this court dealt with in the case we're talking about.
In Warger, the court found that personal story was more part of her subjective philosophy. And here, if the statements were more generalized that all Muslims are terrorists, that would not be admissible because that would fall under the internal matters that Warger defined. But here we have outside trial facts relating specifically to Mr. Habib as a terrorist, and then we also have facts of the case.
But there was nothing specific about him. I mean, he was being painted with the same brush that those jurors evidenced an attitude toward all Muslims. How is that any more external?
It was specific to him, Your Honor, and as reflected...
What was specific?
Here, juror number 2 stated that Mr. Habib was using these Genius watches, meaning the Genius watches at issue in Mr. Habib's trial, as a terrorist plot. That information was never introduced at trial, and certainly had the government had that
You know,
Was
information.
it true? Was there any suggestion there was evidence of that?
It's actually not required that this information be true. And in this case, it's more harmful when this information is untrue, as in this case.
Well, in the Supreme Court case that you just referred to, the name of which escapes me, Justice Sotomayor said that, generally speaking, information is deemed extraneous if it derives from a source external to the jury. And she cited from another case, external matters include publicity and information related specifically to the case. This is not. What you're talking about doesn't really fall within that category.
Yes, it does, Your Honor. And the reason is that this court should not draw a line so arbitrary. If a juror had stated, I read in a newspaper article that Mr. Habib was affiliated with a terrorist organization, there would be no discussion that does not constitute extraneous prejudicial.
But why isn't that different from expressing your view, even if it happens to be a very racist view? But what's wrong with the jury, that particular juror in the jury room, participating and giving his views as to what he thinks about this individual? Why is that extraneous information that must be prohibited? And if in fact it should be, shouldn't that be dealt with at voir dire when you ask the jurors the specific question as to whether or not they have any biases?
A couple points to that, Your Honor. First, as to the 606B issue, Mr. Habib was convicted likely on bias and not evidence. And that's the reason why this type of testimony should come in.
Could I ask you a question about that? What are you specifically complaining about? Here we have 3 jurors who actually expressed what we could say for shorthand, a clear indication of bias based on the fact that he's a Muslim. But as I understand your argument, it turns only on the fact that after the jury, they made these statements after the jury was split 11-1, and it may have influenced one juror. So are you complaining about the fact that it influenced one juror, or that these 3 jurors were biased?
The fact that it influenced one juror, Your Honor, and at this point, the inquiry is simply a threshold inquiry. Whether this extraneous prejudicial information was introduced, and once this court remands this case so that Mr. Habib has an evidentiary hearing to assure that his Sixth Amendment right to a fair and impartial jury was not violated, then the court would ask that question of whether that juror's vote was actually affected. But returning to Justice Brody's Sixth Amendment question, here Mr. Habib's Sixth Amendment right was certainly violated. And that's a separate avenue that this court can admit this testimony if this court is not convinced by the 606B2A exception. The Sixth Amendment allows for an evidentiary hearing in these types of situations. The First, Seventh, and DC circuits have recognized that Rule 606B is sometimes unconstitutional as applied. So that's not to say that Rule 606B is always unconstitutional, but in rare and serious circumstances, like the case at bar, this rule is unconstitutional. And trial courts are apt to make these types of judgment calls of whether an evidentiary hearing should be held. By way of example, in the DC Circuit in Kittle versus United States, the DC Circuit declined to hold an evidentiary hearing because the remark was offhand and too generalized. So trial courts are apt to make these types of decisions of whether the statement was more than generalized bias and actually do require an evidentiary hearing to assure that a defendant's criminal or Sixth Amendment right is not violated. In Tanner versus United States, this court identified 4 procedural safeguards in finding that a defendant's Sixth Amendment right was not violated and actually avoided the constitutional question. However, the context there was much different than the case at bar. Juror intoxication. Jurors were drinking alcohol, smoking marijuana, ingesting cocaine, and the court found that the procedural safeguards of voir dire, the ability of a juror to come forward before a verdict, direct observation of the jury, and non-juror evidence was enough to protect a defendant's Sixth Amendment right. But here, those procedural safeguards simply do not have the same bite in the context of juror bias.
Why not, counsel? I don't understand that. What if, in fact, these jurors were asked at voir dire whether or not they had this bias, or certain questions were asked to figure that out? wouldn't that provide the protection that you're saying your client needs?
No, Your Honor, and as seen in Warger versus Showers, jurors sometimes lie in voir dire, jurors don't want to reveal their prejudices, and jurors sometimes are even unaware of their own biases.
Understood, but your client isn't entitled to a perfect trial, right? He's entitled to a fair trial. And part of the process of ensuring that is making sure that the appropriate questions are asked during selection of the jury. Why is it that we should go beyond that and conduct a hearing to figure out what these jurors talked about during deliberation?
The reason is that voir dire was simply ineffective in this case.
How
As
do we
reflect-
know he didn't, as far as I could tell from reading the record, I could be mistaken, the jurors were never asked.
That's true, Your
So
Honor.
how do we know? I mean, we don't even have a test of your premise.
That's true, Your Honor. And hindsight is 20/20. And while in hindsight it may appear that these questions should have definitely been asked, at the time, defense counsel could have had a strategy for not asking those questions, perhaps to not make jurors feel uncomfortable about delicate issues. But above that, there's also the issue that, as reflected on page 38 of the record, defense counsel did use 3 peremptory strikes and a 4th strike for cause to weed out biased jurors. So defense counsel used the
Based
mechanism.
on what? If he hadn't asked questions during voir dire that would elicit that information, was he going on his own gut reaction as to who he thought might be prejudiced, that by applying his own prejudices?
Perhaps, Your Honor. It's not clear why.
So why, because he doesn't inquire at voir dire, should we give him a chance to take a second bite at that apple and peer into the jury room in a way that we've obviously been reluctant to permit? I mean, it may be because jury deliberations are a lot like legislation and sausage making. You don't really want to look too carefully at what happens. We have to trust the system. And so we depend upon voir dire and other techniques to weed out prejudice. But prejudice is a reality. I don't understand an operating rule that works here that wouldn't cause the breakdown of the jury system in any case that involves somebody who's a minority.
A couple points to that, Your Honor. First, a criminal defendant should not be punished because of defense counsel's own strategy during voir dire.
Well, trust me, that happens all the time.
Unfortunately, yes, Your Honor. But above all, this court stated in Warger versus Showers that there may be cases of juror bias so extreme that almost by definition the jury trial right has been abridged. And though this court did not have the facts before it then, it stated that there may come a day where those facts are present. And that's exactly what this court has before it. Egregious facts where jurors were accusing Mr. Habib of being a terrorist, of using genius watches as some sort of terrorist plot. This information was never introduced at trial, and jurors number 2, 8, and 9 intimidated the one dissenting juror, juror number 5, into changing her vote from not guilty to
That's
guilty.
really what happened here, isn't it? Intimidation, the holdout juror was pounded into submission. But that happens all the time, too.
Yes, Your Honor, that is unfortunately true as well. But what happened here was more than mere intimidation. As reflected on page 27 of the record, jurors number 2 stated that after they locked up Habib, they would lock up juror number 5 as well. The level of intimidation here is simply unacceptable. Mr. Habib was denied his right to a fair and impartial jury from what happened in the jury room. Defendants should be convicted on evidence and not bias. Thank you, Your Honors.
Can I ask you one
Sure.
question outside the record? Were you in any way, by the rules, prohibited from arguing that you were entitled to relief simply because there were 3 obviously biased jurors?
I'm sorry, Your Honor, I didn't quite hear your
Were
question.
you precluded by the rules of the competition from arguing that there were 3 obviously biased jurors, and that should be a basis for which you could get relief under this footnote 3 and that you just referred to?
No, the rules do not preclude that, and Your Honor is certainly correct that the bias exhibited by these jurors certainly denied Mr. Habib his constitutional right. Thank you, Your Honors.
Mr. Chief Justice, and may it please the court. My name is Emilia Rinaldi, and along with co-counsel Aaron Weiss, I represent the respondent in this matter, the United States. This case presents 4 issues. I will explain first why, under Federal Rule of Evidence 702, it was correct to exclude expert testimony to the credibility of a witness. And second, why, under the collective entity doctrine, it was proper to preclude petitioner from invoking his Fifth Amendment privilege and resist the government subpoena. Mr. Weiss will address the remaining two issues, both of which concern why petitioner is not entitled to a new trial, despite statements of juror bias made during deliberations. With respect to the first issue, this court should affirm the decision of the 14th Circuit and hold that an expert may not testify as to the ultimate determination of the credibility of a witness. This type of evidence is prohibited for two reasons. First, it usurps a critical function of the jury, and second, it is unduly prejudicial.
But does it, counsel, wouldn't the jury have been instructed that that expert testimony is like any other and they can accept it or reject it? And isn't that what jurors do all the time?
Yes, Your Honor. However, the way this court pointed out in Dauber v. Mero, Dauber Pharmaceutical, the opinion of an expert brings with it such a powerful, it carries such a powerful weight that oftentimes lay jurors are, one, unable to fully assess that testimony, and two, likely to lose their common sense and simply accept what the expert is telling them basically to how to come down on especially on a credibility determination, which
Is there
is
anything
something.
that prevented the government, the prosecutor, from coming in with his own expert and trying to counter what Dr. White had to say?
No, Your Honor. However, the trial judge had ruled before trial in limine, excluding that contested portion of the testimony. However, even if that had not been the case, realistically, here, it would not have helped to bring in other expert. It would simply, again, have created more confusion in the mind of the jury.
But why is it confusion and not just an opportunity for the jury to be able to make an assessment based on all of the information? Isn't that what we want to do, make sure the jury has the breadth of the information available?
Absolutely, Your Honor. And that is why the government never contested Dr. White's testimony as to his diagnosis of Roberts and of the symptoms that reading disorder manifests in an individual. Paragraphs 1 through 12 of the doctor's affidavit were fully admitted at trial. The only thing that was left out was his conclusion about whether or not the witness was to be believed once the witness was taking the stand.
And isn't that important information for this jury, especially where Mr. Roberts was the government's main witness here, right?
Yes, Your Honor, he was.
He has a cooperation agreement. He's granted immunity. Shouldn't the jury be given this information based on the doctor's opinion, which is a result of his examination of the witness, especially because he's one such a critical witness, has immunity, and has a reason to lie?
Yes, Your Honor, and the government's position is that the jury was given that framework in which to make that determination. Not only the jury was aware that this witness suffered from a mental condition, they were also aware that this witness had an agreement with the government, both of which facts may have very well led a jury to believe that perhaps Robert's testimony wasn't completely truthful because he virtually had nothing to lose. Moreover,
And yet they convicted the defendant.
yes, Your Honor, that's precisely the case. They found him guilty.
Doesn't that suggest that perhaps the bits and pieces that Dr. White was allowed to communicate with them didn't turn out to be enough? Suppose we'd accept as true that the proposition in paragraph 13 that he was not allowed to testify to, that is, that in circumstances like this, Mr. Roberts was not likely to testify truthfully. Your concern is that the jury hearing that would have reached a different verdict. But isn't that logical? If in fact that we knew it was true that Mr. Roberts was likely not to testify truthfully in that circumstance, we would expect the jury to come up with a different result, and we'd want the jury to come up with a different result. So why should the jury not be able to hear what was said in paragraph 13?
Well, Your Honor, because that would simply have put the expert's stamp of disapproval in this case as to the statements that Roberts gave on the stand. We have no indication that Roberts was lying on that stand. We know that he has suffered from a condition that perhaps could have made more likely for him to lie. But we have no indication other than 12 members of the jury thinking that he did not in fact lie and believe in his
Yeah,
testimony.
but the evidence that was excluded simply said that Mr. Roberts will be unlikely to testify truthfully. So I think that's almost what you just said. So why wouldn't the jury be permitted to hear it?
Your Honor, for two reasons. First, because that type of testimony is completely outside the expertise. Dr. White, while a psychiatrist, is not an expert in lie detecting. He cannot tell the jury, with the weight of his expertise, that this witness would lie and thus would not be believable. But moreover,
But
because
the proffer wasn't that strong. It was slightly weaker. It was that he would be unlikely to testify truthfully.
yes, Your Honor, that is true. He would not have pointed to specific statements. However, he would have told the jury that this witness would have been particularly prone to lying, and thus he was not believable. And moreover, this type of testimony runs afoul of Rule 403 gatekeeping function, where evidence can be left out, even relevant evidence can be left out if its probative value is undermined by undue prejudice.
But
And
isn't
this
the probative value and the prejudice here exactly the same? It's not prejudice because of something outside. It's not prejudice because this person is truly sympathetic and we ought to cut him a slack or so forth. It's saying specifically this person is not likely to be testifying truthfully in this courtroom because of the stress and because of this disorder, Reed's disorder, that he has. It seems to me the probative value and the prejudice is exactly the same, and most evidence is meant to be prejudicial, otherwise you wouldn't bother to admit it.
Absolutely, that's absolutely the case, Your Honor. Every piece of evidence.
So why
is
does 403 doesn't keep out prejudicial evidence?
unduly prejudicial?
Not if the prejudice is what's probative about it. I mean, if you've got a witness that said, I saw him commit the murder, that's very prejudicial. You don't keep it out for that reason.
No, Your Honor, that is correct. However, in this case, that wasn't the testimony that was left out. The testimony that was left out was an expert putting a stamp of approval to a witness, or disapproval to a witness statement. So it was not a fact witness in this case. It was an expert
Ordinary auto accident, and the witness, the driver, says, I didn't do it. The light was green when I went through, and an expert comes on and explains with all the information from the traffic light and so forth that no, that couldn't have been the case. The witness is being criticized by the expert. We let that testimony in all the time.
Yes, Your Honor, we do let, and in particular, we do let testimony regarding, for example, whether a witness was able to even see the light being green. However, again, that is a different type of evidence. That is evidence to a particular condition, which again was allowed here. It's not evidence as to whether or not the witness is telling the truth at trial. And
So that there's a difference from, let's say, an eye doctor saying with his condition, I think it's unlikely he would have been able to witness what he testified to.
yes, Your Honor, because that is,
Even though the witness actually testified to it, so he's essentially contradicting the witness.
yes, Your Honor, because that is the type of testimony that Dr. White was allowed to give in paragraphs 1 through 12. That is that type of testimony. And in this case, that type of testimony was allowed, and the government doesn't contest that type of testimony. And moving to the second issue, this court should affirm the 14th Circuit and rule that the collective entity doctrine applies to former employees. Now, you have heard from petitioner stating that much about the testimonial nature of Habib's act of production. However, the question of testimony, whether or not that production is testimonial, this court shouldn't even be reached in that question. Because if the collective entity doctrine applies, as the government strongly affirms, then that question is meaningless. The collective entity doctrine states that because corporations can only act through their agents, an agent of a corporation is not entitled to assert a Fifth Amendment privilege, regardless of how testimonial that act of production
But
really
did
is.
this corporation exist at the time?
Yes, Your Honor. At the time Habib took the documents, he was the CEO of the corporation.
No, I don't mean at the time he took the documents. I mean at the time that the government wanted to get them.
Yes, Your Honor. The corporation was still in existence.
But he had no relationship with it.
He had no employment relationship with the corporation. That is correct.
Is there any evidence of any other kind of relationship he had on a current basis?
He was in possession of corporate documents, Your Honor.
So, but any relationship beyond that? I mean, I used to practice law before I became a judge. Someplace in my boxes, I'm sure I have materials that came from the law firm. Does that mean I'm still an employee, or I'm entitled to be paid by the law firm and have some kind of rights there?
No, Your Honor, you're certainly not an employee, and certainly Abib was no longer an employee at the corporation. However, it is the nature of the document that keeps that relationship alive. And I will point this court to this court's opinion in Fisher v. United States, where this court was looking, among other things, in order to assess whether Fifth Amendment privilege would attach to an individual in possession of corporate documents, whether who was the owner of the document, who produced the document, and whether or not the documents were produced in the regular course of business. All of those factors apply in this case. Moreover, again,
Didn't Fisher involve an accountant?
yes, Your Honor, Fisher had more steps, if you will, than this case does.
Yes.
Absolutely. However, the reasoning will still stand. Moreover, in that case, as well as in Braswell v. United States, this court looked favorably at the older case law, and I will cite Bellis v. United States, for example, in which this court stated that termination of the employment relationship doesn't terminate the obligation of the individual to produce the corporate documents. That case law is still good law. Moreover, Zodiac knew that Abib had those documents. As I mentioned earlier, Abib was the CEO of Zodiac. And when he took the documents, he did so with Zodiac's knowledge and permission. Permission that was never revoked by the corporation. Because that permission was never revoked, that agency relationship was still flowing through the ownership of those
So he still
documents.
remained the custodian of
Yes.
those documents?
Yes, Your Honor, he still.
Even though he no longer had any relationship with the corporation?
That's correct, Your Honor. He was still a custodian because that formal agency relationship established through the documents was never revoked.
Yes, if his wife told him that we got to clean out the garage, get rid of all these boxes, and he did, would the corporation have any cause of action against him for no longer retaining those documents?
Your Honor, perhaps.
Probably not, no?
Probably not. Perhaps, maybe, at most, some negligence action.
So he had no duty to serve this role as custodian.
Your Honor, he had no duty to serve the role. However, by keeping those documents, he maintained that role. And once he was served the subpoena, he had still an agency relationship through those documents with the corporation. And that is why he is not entitled to assert a Fifth Amendment privilege, because his act of production would not be his own. He would be speaking on behalf of the corporation. And corporations have no Fifth Amendment privilege to rely on. That's what B
Isn't
has.
this all a fiction?
Yes, Your Honor. It is a legal fiction, but it's a necessary legal fiction because corporations can only act through their agents.
Well,
If-
do you think it makes a difference here that the very documents you're trying to obtain are the documents you're trying to use against the person who you're trying to get them from? Should it matter?
No, Your Honor, it should not matter. The Fifth Amendment will always protect somebody who is turning over documents that may incriminate them. However, the problem is that when an individual is acting on behalf of a collective entity, that individual does not possess a Fifth Amendment privilege on which to rely and on which to keep those documents secret. No matter how.
Except he's the very person you're trying to use the documents against.
That is correct. No
He's
matter.
the defendant in this case.
Absolutely, yes.
And you want him to produce these documents, as your adversaries argue, to be used against him.
Yes, Your Honor, that is
Why
correct.
shouldn't he be allowed to assert a fifth?
Again, Your Honor, because he's acting as the corporation. And as the corporation,
But
he
is
has.
he, simply because he happens to have the documents, why not get them from the corporation? I understand that here, they don't have them because they destroyed the computer. Probably Mr. Roberts did, because he didn't want to have to turn them over. So why is it that you should be allowed to get these documents from the petitioner here?
Your Honor, because giving this privilege to a former employee will create a dangerous loophole where a corporation will all of a sudden be allowed to shield documents, incriminating documents, from the government by simply, I see my time, may I finish?
You can finish,
You
yes.
can finish, and I'd actually like to follow up with a question.
Go ahead.
In
Absolutely.
this day and age, counsel, is that really going to happen? All documents are stored electronically.
Yes, Your Honor, but as we see in this case, Zodiac purposely kept only one copy for security reasons. And that's something that might very well happen in many other corporations. If we allow a former employee to simply shield those documents, we are essentially saying that if the corporation may assert a Fifth Amendment privilege through his employee. Thank you.
Thank you.
Go ahead.
Mr. Chief Justice, and may it please the court. My name is Aaron Weiss, and as co-counsel, Ms. Rinaldi stated, I will be discussing issues 3 and 4 in this matter. I will explain first why statements of religious bias made by jurors during deliberation are not extraneous prejudicial information and thus inadmissible under Federal Rule of Evidence 606, and second, why a criminal defendant's Sixth Amendment right is sufficiently protected by the procedural safeguards established by this court in Tanner versus United States. What the petitioner is currently asking this court to do is overturn 230 years of precedent in protecting the secrecy and sanctity of juror deliberations, and instead, this court should affirm the 14th Circuit's decision, that these statements under Rule 606 were inadmissible for 2 reasons. First, such biases were inherently internal to the jurors, and second, this court's holding in Tanner does bar such testimony.
Counsel, you will agree, will you not, that these types of biases are the very things we try to keep out of the jury room, and that it was extremely prejudicial to the petitioner here?
Your Honor, that would actually start me with the fourth issue in this case, as to whether or not the defendant received a fair trial by impartial jury. And Your Honor is correct that every defendant is guaranteed that right. However, while we can guarantee a fair trial by impartial jury, we are not able to guarantee a perfect trial by a perfect jury in every case. And thus, as this court established in Tanner versus United States, there are existing procedural safeguards that protect a criminal defendant and his Sixth Amendment rights. Specifically, those are voir dire, juror observation by the court, juror observation by fellow jurors, and finally, non-juror testimony. And in the idea of balancing the defendant's Sixth Amendment right with, again, this interest in protecting the secrecy and sanctity of juror deliberations, these existing safeguards would be a better means to find potential in the future biased jurors than to open the door to essentially what is this black box of juror deliberations. To the first procedural safeguard of voir dire, as Your Honor mentioned, that was never brought up by defense counsel at the trial level. And to allow them to do so today would essentially be ruling that if you do not do so during the trial, and then they can come before this court and argue that they should have, that would be giving them a second bite of that apple.
Well, would it really? I mean, if you weeded the people out at voir dire, we wouldn't be in this boat, but we are in this boat. We know now that at least 3 of the jurors expressed, or at least are related to express, we haven't had an evidentiary hearing, but we have to accept for the moment the proposition that they related some very racist sentiments, and that it's not implausible to conclude that the verdict was based upon their belief that Mr. Habib was a Muslim and hence a terrorist. Don't we want to prevent that, however we come into the information?
Your Honor, we certainly do want to prevent that. However, the issue
So why
is,
do we close our eyes to it if we get the information this way?
well, Your Honor, the issue is if we begin opening this door today, it would go against the policy arguments that this court made in Tanner. Those are assuring a full and frank discussion among the jurors, preventing juror harassment, and assuring a finality of the verdict. So if we allow now to essentially open this door to the juror deliberations just because maybe a statement was made, then that would in fact not be, it would be against these courts' interests. Instead, we have other means of discovering this information than looking at the jury deliberations themselves, such as had defense counsel asked questions during voir dire. And likely, it is very possible that some of these jurors would have come forward and explained that bias, because jurors during voir dire are under oath and penalty of perjury that they must tell the truth in those situations. So therefore, it is likely that voir dire alone—
You know when the last juror was prosecuted for lying at a voir dire?
I'm sorry, Your Honor.
I said, you know when the last juror was prosecuted for lying at a voir dire?
You are correct, Your Honor, in Warga versus Showers that there was that issue before this court. However, this court ultimately ruled to uphold that verdict.
Yeah, but there's also a footnote in that case which says that there may be there may be cases of juror bias so extreme that almost by definition the jury trial has been abridged. Isn't this such a case? I mean, it's not just, as I look at it, what effect these comments may have had on juror number 5, I think it is, but the fact that you had 3 jurors who were obviously, by the statements they made, terribly biased. And, you know, there's an expression in death penalty cases that death is different, but issues relating to race and religion in terms of the jury room, shouldn't they also be different?
Your Honor is certainly correct that footnote 3 does state that there are some situations such as this. However, that is not what respondent argues is the case before this court today. Here, if we look at the underlying facts of deliberations, there was an initial vote where 11 jurors voted guilty in the initial vote. And then after that, there were statements made. However, that vote only occurred after 6 hours of deliberation. Thus, it's not quite as extreme as what footnote 3 seems to suggest, that it was so biased and so outrageous that just from the beginning, it violated these rights.
But why didn't it? The fact that these 3 jurors thought the way they did and felt free to express it and to use that information to badger juror number 5, doesn't that suggest that in fact there was a problem with the jury as a whole, not simply because of the fact that they badgered this particular juror?
Your Honor is correct that certainly there is an underlying issue with these 3 jurors. However, it doesn't meet quite that threshold that this court suggested in footnote 3. However, there are again available.
Why not?
It doesn't meet it, Your Honor, because again, there were over 6 hours of discussion in this case and an initial vote of 11-1. So therefore, it's different than, say, a hypothetical where within the first.
You're assuming that the 3 of the 11 were people who were flatly biased. That's a significant number. And
3.
And then ultimately of the 12, you have to add at least 1 more.
3 of them were, Your Honor. However, again, this is just to highlight that what this court was concerned with in footnote 3 is not precisely the case here. However, returning to the procedural safeguards, there are again other available remedies to look into what occurred with these jurors rather than looking into the deliberations themselves. I'd point this court to the 4th procedural safeguard of non-juror testimony. And to give an example of where non-juror testimony can work was the recent case against George Zimmerman. There, defense counsel was able to use social media. By logging on to Facebook accounts and Twitter accounts of the potential jurors, they were able to see biased statements against either the defendant himself or Hispanics generally, and able to use that information to bring forward the potential bias that these jurors had. So again, that other procedural safeguard articulated by this court would be a better remedy to use than to simply open this door to the jury deliberations altogether. They're essentially ruling today that in this case, we could open this door and allow the courts to consider what jurors are doing during deliberations would essentially create a trial about every trial. Because then if the defense counsel loses, they will necessarily want to contact every juror and see if there's any reason that they can get that case overturned. And it will essentially flood this court and the appellate courts with a discussion among whether or not what occurred during deliberations was correct. What we ask jurors to do every day is to go into the case and consider both the evidence before them as well as their personal beliefs that they bring with them into the room. And this transitions back into the 3rd issue in this case as to whether or not the information is admissible under Federal Rule of Evidence 606. Respondents believe that the definition Your Honor cited as to Warger versus Showers is the exact definition of extraneous in this case, deriving from a source that is external to the jury. An external would be such as had one of these jurors gone home and Googled the defendant's name and seen his name on a list of known Al-Qaeda members. That would be an example of extraneous information against this defendant that they used in that situation. However, here, all we have is what Justice Sotomayor referred to as the internal beliefs of those jurors, that being their own personal experiences and backgrounds that they bring in with them to these deliberations.
Suppose the report of the juror was, I searched the defendant's name, and it turns out he's a Muslim. I've got a picture of him standing in front of his mosque. And then all the other things that he says about towel heads and terrorists and so forth. But they did have that one extrinsic photograph, is that going to be enough to make a difference?
Your Honor, as to the photograph itself, yes, it would, because there it is an extrinsic piece of information.
So gleaning the fact that he's a Muslim out of this photograph instead of inferring it from his name makes all the difference.
Correct, Your Honor.
Why?
And we see that through this court's decisions in, for example, Maddox versus United States, where this court explained that something that would be extraneous is a newspaper article that the jury considered in making their ultimate determination.
Oh, I know what's different about the facts, but why should that produce a different outcome?
Your Honor, the reason would be the language of Rule 606 itself, as we interpret these rules based on their plain language. And here, this term extraneous is whether it derives from a source external to the juror. So in your hypothetical, where the juror didn't refer to their own personal beliefs, they referred to a photograph. So there, that photograph is what is external to the juror. However, in this case, what we have is the jurors calling upon their own beliefs in making this determination.
Well, in my hypothetical, it was the beliefs prompted by the discovery that the defendant, whose name might not have been quite as obviously likely to be a Muslim, triggers the same set of beliefs. And I understand what's different in the hypothetical, how there's more obviously extrinsic material in my hypothetical, but I don't understand why there should be a practical difference. Why should the bottom line be any different when what's really being unleashed is this intrinsic prejudice?
Your Honor, again, I would point this court to the policy considerations that it expressed in Tanner versus United States, assuring that full and frank discussion, preventing juror harassment, and assuring the finality of the verdict. If we hold today that in this case, such a thin line as whether the information was obtained by the thoughts of the jurors or in the hypothetical a photograph, then necessarily every defendant will be contacting these jurors and looking into what they decided, and that will erode the jury system's finality.
In this case, is there any evidence that juror number 3 was contacted initially by Habib's counsel?
There is not, Your Honor. The record does indicate that in this case, they contacted voluntarily.
So maybe there's a distinction. We don't have to worry about going out and calling jurors if the jury volunteers the problem.
It is true, Your Honor, that in this case, however, any ruling that this court decides today will be universally accepted by all of the courts below. And so therefore,
That's why it's good to be supreme.
That's correct, Your Honor. However, the issue with that supreme decision is the fact that now defense counsel will know, even if there's a situation based on the holding today, now necessarily we can go try to contact these jurors.
No. If our ruling is limited to something initiated by one of the jurors, we say explicitly that we're not ruling in the case of lawyers going out and calling. That's a bad thing. Well, let's accept your premise. If we say no, in the instance where the juror himself or herself brings to the attention of the court what went astray in the jury room, we'll consider that. That rule wouldn't produce the horrible result that you prophesize. It would solve our problem here, wouldn't it? Not to your liking, but it would solve our problem here.
It would solve the one policy argument of the juror harassment, Your Honor, correct. However, there are, again, those further policies, such as assuring that finality of the verdict. If we hold today that, again, based on a statement of this juror's supposed...
Well, finality was the be-all and end-all. We wouldn't bother with appeals, would we?
No, Your Honor. However...
I got lots of friends in the district court that would love to do away with appeals, and yet we're a necessary evil. So finality only goes so far.
Correct, Your Honor, and that's why I'm here today, is on appeal.
Well, you're the prosecution. You would have been settled, if no appeal, you would have been happy anyway, so.
Correct, Your Honor. However, honestly, I'm sorry, Your Honor, I forgot the question.
That's quite all right. I'm saying finality is not the sole answer, because finality is a value, but it's only one of several values. And I understand there are multiple values here, but I look into each one, I keep wondering, well, here we have a conviction that seems to be tainted, at least with regard to some of the jurors, as being based more on prejudice than on evidence. Shouldn't we say no to that?
Your Honor, the reason why respondents argue that that would be incorrect would be that, again, looking down the line, what if in the future someone decides, a juror, that they want to vote guilty because there's a baseball game on that night and they want to go home to reach it? That has the same prejudicial effect and that same essentially coercing of another juror. However, in that case, then we'll essentially be opening the door to all jury verdicts altogether, and again, creating this trial within a trial where we will essentially erode the jury system and simply have a district court, if the criminal defendant at trial loses, decide whether or not that verdict was decided properly. And for these reasons, this court should affirm the 14th Circuit on all 4 decisions. Thank you.
Thank you.
A few points on rebuttal, Your Honors. First, as to the juror misconduct issue, this rule would not be opening the door to inquiry into whether jurors want to go home to watch baseball games. This rule would be narrowly construed, as this court stated in Warger v. Showers, to cases that are so extreme that almost by definition the jury trial right has been abridged. And that's exactly what happened here. Jurors number 2, 8, and 9 accused Mr. Habib of being a terrorist and using Genius watches as some sort of terrorist plot. He was convicted on bias and not evidence, and this court should not allow that to happen. Second, as to the 702 issue regarding Dr. White's testimony, respondent argues that the prejudicial nature of this testimony outweighs the probative value. That's a 403 inquiry that would come after the 702 inquiry. The 702 inquiry is simply a threshold inquiry. So this case should be remanded so that the district court can make that proper 403 inquiry. And lastly, as to the collective entity doctrine and Fifth Amendment issue, respondent misdirects this court's attention to a loophole concern regarding former employees harboring corporate documents. But the real concern here is the constitutional concern. Essentially, this rule would be requiring criminal defendants to testify against themselves in their own criminal trials.
Where's the testimony?
Here is the fact that Mr. Habib is producing these documents, and that's an essential link in the chain here.
We've been through this. The jury never heard it. So, but let me ask you this. Suppose they got a search warrant here and they searched his house, but they didn't find these documents. Suppose they had found the documents. There would be no issue as to their admissibility, would there? Assuming the search was valid, obviously.
No, Your Honor.
There would be no Fifth Amendment issue.
That's correct.
That's because they got it without any authentication on his part. And here the jury, in the same way, never heard that he was the producer of the document. So it seems to me it's no different, is it, than if they had taken it, if they had found it the first time when they got the search warrant.
I see my time has elapsed, if I may answer your question. Mr. Habib was not provided immunity as to the act of production, and the act of production is testimonial here because it shows that Mr. Habib had knowledge of that these documents existed, and that's essential to the elements in the charges against him. That would be self-incrimination and under the Fifth Amendment. Thank you, Your Honors.
Everyone could be seated. We're going to have a few words just from our dean, Nick Allard, before then I get back up to speak, introduce the judges, and then we'll get to the awarding.
Thank you, Katie. Well, I think we have our new recruiting films. Should I bring those to SCAD and ARPS tomorrow night when we meet our new admitted students? What do you think? Is there a good copyright lawyer in the audience? I'm sort of glad the judges were not here, huh? Congratulations to everybody who put that together. It was marvelous, and Katie. Don't ask. Okay. So, I Accuse, starring Jose Ferrer, To Kill a Mockingbird, starring Gregory Peck, Witness for Prosecution, starring Charles Lawton, Inherit the Wind, Philadelphia Story. These are movies, films, theater that make us incredibly proud to be lawyers and inspire us. This moment today, this whole program, is incredibly inspiring and a moment of pride, and it's not theater. It's real. And it's so inspiring to have all the judges who have helped us and our three incredibly distinguished jurists to devote their time and energy to mentor and help advance the rule of law and justice by helping people perfect their skills as lawyers. It's incredibly inspiring and a moment of pride for us to watch all the faculty and coaches and students and people. I'm looking out at Roman, I see you back there, who might have had, guilty as charged, right? Might have had a hand. And all the participants and the finalists that we've just seen. It's just incredible. Now, to the finalists and to all of you, we've been hearing rave reviews about the arguments. We've been hearing rave reviews about the briefs and the written work. And, you know, it's such an important skill for you to be able to rise up in your hind legs and argue, to advocate. And we've seen an exceptional example of that. And it's incredibly important to be able to write in a persuasive way on behalf of your position, and you all have done an incredible job. So all of you who've participated this weekend, and certainly the finalists that we've seen before us, you are lawyers. You may not have your JD yet. I know you don't. And you certainly haven't approached the bar exam yet. By the way, we're working on that. Make it a little bit better experience for you and more meaningful. But you are lawyers. You're ready to go. And so I know it is our hope and expectation, and the reason that all of the faculty and all of your great law schools, and certainly this great law school, students are not our excuse for having a law school. They're our purpose. And we want you all to use what you have developed and your great talent that you've demonstrated today and this weekend for a purpose. And that purpose is to be the architects of economic opportunity and to be freedom fighters and also to be champions for equal justice under law. So go out and make us as proud in the future as we are of you today. I especially want to thank the three judges who are here. Judge Richard Clifton from the Ninth Circuit, probably in the 30 years of the Prince competition, may have come the longest distance. He has a remarkable background. If you didn't go to St. Francis College or Brooklyn College, Princeton and Yale Law School, they're pretty good. He's had incredibly distinguished career in private practice and clerked with, I guess, the first judge to sit in Hawaii. And now he's there in Hawaii on the Ninth Circuit, appointed by President Bush nominated 1 week before 9/11, and been serving since, confirmed very soon after. A vote of 98-0 I saw. That was the last time probably the United States Senate agreed on anything so completely. There may have been a few other examples. We're very, very glad to have him here with his wife, Terry. Thank you so much for spending time with us. I almost said that Judge Margot Brody is an old friend of Brooklyn Law School, but she's not old. In fact, she's incredibly young. She's a long-time supporter and very much involved with the law school, including teaching, and she is not only a mentor, but you know, an inspiration and somebody who people can aspire to use their legal degree in a way that she has, not only in private practice, but in public service. In the United States Attorney's Office, for example, she held many of the top positions in the criminal division and was appointed in 2000, nominated, I keep saying appointed, nominated, I should know that since I worked in the Senate so much, nominated for the bench on the Eastern District by President Obama and confirmed and took her position in 2011 or 12 or 11? 12, okay. So we're very, very privileged to have her here, and we thank you very, very much. Thank you. Our Chief Justice today is a person, there is no other living person. You know, I've been known to embellish a little bit, maybe to exaggerate. My own son said that I put the BS in BLS. But there is no living person who has a closer connection, has devoted so much time and energy and effort, and who cares more about Brooklyn Law School than Judge Ed Corman. He's not only a graduate of this law school, he has been somebody who is iconic in his accomplishments as an alumni of this law school, from private practice to including clerkships, service as an assistant solicitor, the Chief Judge of the Eastern District. I'm not giving you these chronologically. The United States Attorney. I mean, remarkable public service and achievement because of his great skills as an incredibly outstanding lawyer. But what is not seen is the effort and time and energy, not only as a longtime member of the Board of Trustees and Vice Chairman of the Board of Trustees, but somebody who insinuated himself into this Prince competition and has recruited judges and consistently, you know, presided himself and helped in numerous ways. And I know that he's been extremely helpful to me, giving me suggestions constantly about who to meet or how to approach a particular problem. So it was deep pleasure that we thank Judge Ed Corman for being here with us today. Judge Corman, thank you. Now, to the contestants, I've got to say, as an observer, you were not facing a pushover panel today. And one of the things that's amazing that maybe, you know, you all agree with me if I mention it, but you may not be thinking about it. One of the remarkable traits is how well each of you could take a punch and keep going, which is a real skill. So that's for my 2 cents worth, you did it with courtesy and sometimes humor. And you were incredibly impressive. The Moot Court Honor Society, all of you deserve so much gratitude from all of us for making this weekend run so well. The amount of time that you put in while you're doing your studies, I hope, is remarkable. And I said at the start, the only thing that I was sure about the outcome was that one of our teams would not win. And there's history to that, so we don't participate. But I know, for example, I just got an email. Last week I reported that we had 3 teams. They were all winning at different levels and different accomplishments in different parts of the country. And this weekend, I just heard this morning from the team that's in Oxford competing in an international competition. And they have won. For the second year in a row, one of our students has won the best oralist, and we won 3rd place in the oralist, and then best brief, and so on. And one of them I don't quite understand. We placed in the octagon or something. Somebody said the octo round or whatever. They told me that means they won 8 times. I'm not quite sure that's right. You all know what that means. So in any event, this is a moment of incredible pride. It's also a poignant moment because the man who you saw at the end of the video, Robert Pittler, was the driving force behind this competition. It was very near and dear to him. And as I said that students are our purpose, he certainly embodied that. And while it's difficult to say goodbye to a good friend like that who passed away last week after a long illness, it is comforting to know and to see visible examples of his legacy and how he's insinuated himself in the DNA of this place and these students and this competition. He was, in fact, I think it was his idea, the Genius Watch, it was his idea, and it came from Bob. And so this is something that I'm sure is making him very happy right now to see how well this whole program is run. And so, because of all of you, we're going to have a little bit of Pittler going forward in the future. Thank you all very much for a wonderful experience for us.
Thank you, Dean Allard. Just a few more minutes and then we'll get to the awards. I'd like to thank all the teams once again. We've had high praise from all of the judges, from the preliminary rounds through the upper rounds, about the quality, the skill, and the level of competition that we've had here, so you all should be very proud. Brooklyn Law School is very proud themselves of the Prince competition, and you have done it justice and held up in the 30th anniversary. This is our 30th year here, and it just keeps getting better each year, so thank you. Before we announce the results of the final round, there's a few individuals here that we'd like to thank. First, the competition couldn't happen without the help of our faculty advisors, both for Moot Court, for the Prince competition, and for writing the problem that you've all worked on very hard over the last few months. So we would like to thank Professor Cynthia Godso, I believe she was unable to make it here tonight, Professor Neil P. Cohen, who is supposed to be a semifinal judge and developed illness and was not able to come here, but he helped write the problem that you all had worked on, so. And in addition, we would like to thank very much Professors Mary Falk and Professor Ursula Bentley, and if you can come up for something, we would like to say thank you to you. I'd like to say a special thank you from myself. Professors Bentley and Falk worked very hard with me day and night on the competition. Problems, questions, comments. I can honestly say the competition wouldn't happen without them. Another few individuals we'd like to thank are the Prince writing team. We have 5 students that write the problem in conjunction with the professors here every year, and so I'd like to invite them up for their thanks. That would be Sean Anderson, Chris Coyne, Tristan Ellis, Brendan Gibbons, who is actually on that Oxford team and is unable to be here, and Ashley Huddleston. So we just want to thank them for their hard work. They are all on journals, on Moot Court, coaching, competing, and doing all sorts of other schoolwork in addition to writing, researching, and working on that problem for the last 8 or 9 months. So thank you. Another few individuals that I just have to mention are Beth Palastro and Chris Gibbons, who work behind the scenes, put up with literally emails from me at 3 o'clock in the morning and then again at 7 o'clock in the morning, making all of the competition run, making sure all the rooms go smoothly, putting the banquet together, putting all the events together, and so I can't thank them enough for helping to plan the competition. Yes, and Casey Davis, who's also joined us this year. In addition to them, I have a wonderful Prince committee. There are some of the 2Ls and 3Ls that work on Moot Court with me, and they have been here, especially this last week, helping to make sure all the bailiffing worked, all the judges were here, all the rooms were ready, and everyone that had helped me here. So thank you guys. In addition, I'd like to thank my Moot Court e-board. We have several members of the 3Ls that have worked together with me. Especially like to thank our Moot Court president, Rebecca Nader. And so many of the students here know, but maybe some of you don't, Rebecca and I actually started the first day of law school together. And so coming to this conclusion at the end of school is a pretty great result. And finally, one last thanks. I'd like to thank my parents who are here today, who are practically honorary moot court members of the Moot Court Honor Society, because they have helped me tremendously with those late night calls and early morning calls and making sure that everything that I needed to get help with, they helped with too. So thank you. And with that, I'd like to turn it over to our final round judges to announce the winners of the competition.
First, as you know, we don't pick a team as being the winner and loser. We fill out these complicated scoring sheets, and I don't know how it all gets done, but I'm told as a result of all these calculations, the winning team is the petitioner.
That's quite a trophy.
We also have the second place trophy, so congratulations. Everyone also gets an individual first place trophy, so you guys get 2 awards to bring home. And we have just a few more awards. So we have Best Oralist, and that goes to Jeremy Bailey, and if I mispronounced that, I'm sorry, from Stetson University. And then we have a few awards for Best Brief. So for first Best Brief, went to William and Mary. Second place for Best Brief goes to UC Hastings. Congratulations. And third place for Best Brief goes to Stetson University. And then we actually just have 2 last awards. From time to time, every few years, we honor people who made contributions to the success of the Prince competition. 2 years ago, we honored the competition's greatest champion, Professor Bob Pittler. Today, we're awarding 2 Princey Awards to 2 great friends and proponents of the Prince competition. So first, I'd like to introduce and ask Professor Falk to come up to present the first award.
The first of our 2 Princey Awards goes to visiting Professor Neil Philip Cohen, who had hoped to be here with us and wasn't able to make it at the last moment. Whenever Professor Cohen teaches here, he volunteers his time to help supervise and advise the students who are creating the Prince record and bench brief. Indeed, he gives lavishly, even profligately of his time and his deep and broad, wonderful knowledge of evidence and of trial advocacy as well. His suggestions are always thoughtful, and they are also expressed with a kind of southern gentility that is both welcome and strangely exotic. And I must say for myself that as a colleague, Professor Cohen is an absolute joy to work with. This year, he contributed even more than usual, his wife. Professor Cohen's wife, Riva, is a psychiatrist, and she helped us with our psychological problem. That is, she helped to create Reed's syndrome. So, to Professor Cohen, to Professor Neal, and Dr. Riva, our many, many, many thanks. Come back to Brooklyn soon. And I know that Bob Pittler would be so happy to welcome you, to welcome Neal into the community of lifetime Princey winners. So, thank you, and we hope to see you back soon. Well, yes. Yes. No, I do need to present it to someone. Who do I present it to? Oh, perhaps a team member. Should I accept it for her? Tristan, why don't you come and accept it for us? You can just put it right back down again, but I've got to give it to somebody. Take it.
We did 2 Princey Awards this year, and the second one is especially special to me because it goes to a member of the staff that has been of immeasurable help to me, to the rest of the team. Everyone at the school, I think, has had help from her at one point or another. It's a person with Staten Island smarts and a can-do attitude, a person who could do things with Microsoft Word and Excel that I can only dream to do. This woman is Beth Palastro. I could say personally, I would have been lost without Beth, and I am so happy to have done the Prince competition, if only to get the opportunity to work with her and get to know her. And so it is my honor to give Beth this Princey Award.
She promised me no snow.
And then the one last award, we had still been tabulating for the final score, and the best oralist for the final round goes to Amy Yellen. Sorry, it's never ending. We have a few thank you gifts just for the judges for taking the time to, I know they were very well versed in the bench brief. They did a lot of work getting ready for today, and they were wonderful to help us out.
Thank you. Is it where we thank all the little people that made this possible? I'd like to thank all the little people that made this possible. My agent, my manager. You like me. You really like me. I do want to say one thing, and that is that starting a week from Monday, I'll be spending a week at our courthouse in Pasadena hearing oral arguments. And I can say with complete confidence that the quality of argument that I'm going to hear in those 20-some cases during that week will rarely, if ever, match what we heard today. It's not only because these people are obviously accomplished and talented and so forth, but put in the time to get prepared. And when you go out and practice with real clients, I hope you remember that the preparation time makes an enormous difference in what you're able to accomplish. We've seen today how much extraordinary persuasion you're able to bring to bear, and I wish you great success in your career when you bring that talent for the benefit of your clients, whomever they turn out to be.
And a final thanks to Dean Allard, who is a great support and is always there to help us when we need anything, putting the competition together. So thanks again.
Hello, everyone. My name is Rebecca Nader, and I'm the president of the Moot Court Honor Society. And I'm not sure if you've noticed, but Katie just spent the last 20 minutes thanking a room full of people. But what she forgot to point out to you is that she's the one who has run this competition from the beginning of the summer till today. She has spent countless hours at this school. She knows every single person who works at this school by first, last name, where they're from, their kids' names. She spends so much time here. And I really want to make sure that she gets the thanks she deserves. Katie is one of my best friends, and she is incredibly hardworking. And because of her, this competition was incredibly successful.
Thank you, everyone. I have to say, it was a lot of work, and God knows most of the people in this room know how much time I put into it, but this was by far the best part of law school for me. I had a blast doing it, and actually, if they'd let me stay around next year, I probably would do it again. So thank you. This concludes the presentation. Everything is finished here for tonight. We will hopefully see you all at the reception and banquet over at the Forcelli Center. It'll start 8:30 tonight. It's the top floor of File Hall. If anyone has any questions, any trouble getting there, anything, just find one of the Moot Court members. We'll be around for a little while longer, but we hope to see you later. And thanks again. And in case it wasn't announced which schools were which, it was UC Hastings and Duquesne. So once again, congratulations.